Good morning and welcome to Law Talks here on 4CRB. Well, these days our smartphones hold the keys to almost every aspect of our lives. They can contain access to all areas of our lives. If something happens to you and no one can unlock your phone, your family may struggle to access important information when they need it most. That can create a significant delay and added stress for loved ones trying to manage your affairs if you lose capacity or even after you pass away. To explain why digital access is becoming an essential part of estate planning, we're joined by estate planning lawyer Leigh Steyn from Attwood Marshall Lawyers. Good morning, Leigh, and thanks for joining us.
Morning, Robin. Thanks for having me again.
Well, Leigh, why has access to smartphones become such an important estate planning issue?
Well, I actually think for most of us, our smartphones have just become the control center of our lives. They often provide access to our online banking, emails, superannuation, government accounts, bills, investments, everything, social media, you name it. So I think in many ways they are the modern equivalent of a filing cabinet, a photo album, keyring, all rolled into one. So if something happens to you and no one can unlock your phone, your family may be locked out of the very information they need to manage your affairs if you lose capacity or administer your estate after you pass away.
Yeah, it really is incredible now how much of our personal and financial life now sits inside one small device.
It really is, yeah.
So, Leigh, what practical problems can arise if no one can unlock your phone?
Essentially, a locked phone can create significant delays and frustrations for your loved ones. Your attorney under your enduring power of attorney may struggle to locate an account information or access important emails or retrieve contact details for financial advisors. And then when urgent decisions need to be made on your behalf, they can't get in. And then after death, your executor may find it difficult to identify assets or close accounts or access sentimental items such as family photographs stored in your iCloud.
Yeah.
So what seems like a simple passcode can become a major obstacle and a very stressful time.
And why are security measures like two-factor authentication making these issues even more important?
So two-factor authentication adds an extra layer of security by sending a verification code to your phone or an authenticator app. I think most of us use them nowadays, yeah. So this just means even if your executor or attorney knows your passwords, they may still be unable to access your account unless they can unlock your device and receive those codes. So without access to the phone itself, once again, your loved ones can be shut out of important financial information and even treasured family photos or documents.
So again, those security features designed to protect us can also create unexpected challenges.
Exactly. And we spend so much time trying to protect that information.
Yeah. So what types of digital assets should people be thinking about when preparing their estate plan?
So digital assets, funny enough, actually include much more than just cryptocurrency. That's what most people think that when they think of digital assets. So they can include your email accounts, your cloud photo storage, your online banking, your PayPal, your Afterpay accounts, even things like share trading accounts, loyalty points, your Woolworths points, social media profiles, subscription services, and just any documents stored electronically. So some of these assets may have financial value, while others hold just enormous sentimental value. So modern estate planning is no longer just about your home, bank accounts, and car. It actually also needs to consider your digital life.
Yeah, because there's an app for everything these days, isn't there?
So true.
So should passwords and PINs be included in your will?
Absolutely not. No. The answer is no, no, no. And that's because passwords and PINs should never be included in your will. Once your will is actually admitted to probate, what many people don't know is that it becomes a public document that can be accessed by others. And wills are also commonly provided to institutions such as the banks and government agencies during the administration process. So including sensitive login details in your will just creates a real risk of unauthorized access and identity theft.
That's a really important point.
Yeah.
What is the safest way to store passwords, PINs, and digital account information?
So I would say the most important thing is to have a clear and secure plan. Some people keep a physical folder containing information. Others use a password manage or secure digital record. I recently had a client who called theirs the Fearless folder, which I thought was wonderful because the name, it just gave their family confidence that everything they needed would be in one place. So whatever system you use, it should be kept up to date and stored securely so that trusted people know where to find it when the time comes.
I love the idea of the Fearless folder. Can an attorney use this information if you are still alive but unable to manage your affairs?
Yes, provided you have an enduring power of attorney in place. I think we've spoken about that previously. So this document allows a trusted person to step in and manage your financial and legal affairs if you lose capacity, or earlier if the document is drafted to take effect immediately. So in practice, many institutions will record the attorney's authority on their systems, so they may not always need your passwords. However, having access to your digital information can still make the process much easier and just more efficient.
And Leigh, how often should people update their digital records?
So I believe your digital records should just be reviewed whenever your information changes. If you open a new account, close an old one, change passwords, adopt a new device, your records should just be updated accordingly. Think of it as a living document that evolves over time rather than something you prepare once and forget.
And finally, Leigh, what is your key message for our listeners about protecting their digital life as part of their estate plan?
So your digital life is now part of your legacy. A well-prepared estate plan should not only deal with your home and finances, but also provide a practical roadmap for accessing your devices and online accounts. Taking a little time now to organize this information can just spare your loved ones significant stress, delays, and frustration at a time when they are actually dealing with a great deal already. So, yeah, that would be mine.
Well, thank you, Leigh. Such an important conversation because so much of our lives now exist online.
It does.
Thanks for your time today, Leigh.
Thanks for having me.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.